everyone. Sorry for the delay letting you in. We were just letting our leaders in, but thank you for joining us today. We'll give it a minute or two before we totally kick off. We have... Okay, there you are, Leah. Excellent. I think I know most everyone who's joining today, but just in case there is somebody new who is on, I am Hannah Shea with World Law Group, our Director of Business Development, and I work with our practice and industry groups, of which dispute resolution is one. We have 15. Today's session, we will meet the team from Makarim Itera in Indonesia, who will be hosting our semi-annual summit in May. It's coming up very fast. Before we kick off with meeting the team, and then of course we'll have a discussion on sanctions related dispute resolution. If you could take a moment to rename yourself, I see a number of you have already done so. You can do so by hovering over your own video, selecting the 3 dots at the top, and then there is a drop down called rename, and then you can just add your firm name to the end of it. If you are unsure or having issues doing that, you can always send me a chat message and I am happy to help you with that. Just so that you know, this meeting is being recorded. We do record all of our practice and industry group meetings, and then we post them on the website for you to reference after, for those who have missed it, so that they can see it. So you'll see I have my artificial intelligence colleague, Hannah's Autopilot, with me today. That is our recording service and recording and note-taking service. So the little live stream at the top is not actually live streaming anywhere. It is just live streaming to our recording. With that, I'm going to go ahead and hand it over to Wendy Lin at Wong Partnership in Singapore. She is one of the 3 co-chairs of this practice group, and she represents our Asia Pacific region. So with that, I'm going to hand it over to you, Wendy.
Thanks, Hannah. Hi, everyone. Again, thank you for joining us. On behalf of Philip, Ryan, and myself, we will kick off today's session by handing over immediately to Leah from Makarim. She will give us an introduction of the firm and her team. And as Hannah mentioned earlier, we will be in Bali later in May for the WLG session that will be hosted by Makarim. Now, Leah, over to you.
Thank you, Wendy. Thank you, Hannah. Yes, we are looking forward to see all of you in Bali in this May. Of course, we are hosting the WLG summit there, and hope to meet you everyone here. As an introduction, my name is Leah Alizia. I'm part of our dispute team in Makarim and Taira S. Our office is based in Jakarta. I'm here also together with my colleague Rudy Sitorus. He is one of our senior associates. So I think I sent you, Hannah, my slides. Would you please share the slide to us?
Let me pull those up. Leah, you can share them at the bottom of the screen with the share screen.
Okay.
If you'd like to, let me know if you can't do that, and if not, I will download them and open them up.
I think I can. Everyone can see this.
Okay.
Yes,
and it is. You may want to select presentation mode.
Okay, here we go.
Yeah, right there.
Okay. Right.
Yeah, perfect.
Thank you. So here we are. So basically, our office has 3 major departments. First is corporate commercial, second is banking and finance, and third is our dispute resolution team. So our firm provide full legal service to our clients, and most of our clients are coming from the multinational companies, and we also with the foreign law firm, and then my members like here members in a WLG. So with over 40 years. So we have been around in Indonesia more than 40 years. So we try to provide legal service to our clients, not only giving the corporate and commercial advice and banking finance, but also provide the dispute resolution. So most of our clients, actually, our existing clients who needs us to represent them in a litigation, negotiation, and we provide a broad range of services. So even though basically we provide corporate litigation, but of course we also giving service in not only in corporate litigation, but also in employment, immigration, bankruptcy, criminal. But most of them we serve the corporate clients. Of course, we also assist the individual in the sense of, for example, if we are required to handle like white collar crime, when, for example, the one of the board of member is summoned as, for example, witness or suspect, and in this case, the board of director or director representing the company, for example, in an environmental cases or in anti-corruption, anti-bribery cases. And our client not only coming from the multinational client, but we also serve state-owned companies over the past year. So, for example, in one of our major cases, which Rudy also involved in the cases, our client is state-owned enterprise, under the Ministry of Finance. So it involved various litigation cases, not only the corporate litigation, but also criminal and anti-corruption, anti-bribery, and so on. So we giving our experience to the clients, so the clients will feel comfort with our service because we know Indonesian, the culture, and so on. Next, this is our partners. So we do have 3 partners who be a member of our dispute team. First, Ibu Rahayuning Sihut has been with us for more than 30 years, is the most senior partner at the firm. And the other is Mr. Haris Tongkagi. He's just recently appointed as a partner in our firm. So he representing the client mostly in corporate arbitration, also employment cases. So like myself, I also cover employment cases, commercial, intellectual property, so like enforcement of trademark or copyright issue in Indonesia. So these are 3 our partners. Next this is our associates. So one of them is Rudy, who is joining with us. So we do have, I think we do have 4 senior associates, and the other is mid-level and junior associates. So we do have like around more than 10 members of dispute team in our firm. I think that's all my brief introduction to you. Happy to take any question if you have. Thank you.
Thank you very much. So maybe one question from my end is, do you mainly do litigation in Indonesia, or does arbitration play a major role too?
Yes, that's one thing that probably I miss mentioning about our expertise in arbitration. We do have also represent the clients in arbitration, mostly in construction dispute, and also in corporate litigation. And Rudy is one of our associates who is expert in arbitration. So I think we also did represent the client not only in BANI, in our national arbitration body, but also we did represent the client in SIAC, in Singapore, and we often are required by the clients to give the advice in Indonesian law perspective. Because, for example, in construction dispute, the agreement is governed under Indonesian law. So most of the time, if we help the foreign clients or the foreign firm, usually we will be a co-counsel in the dispute. If I may ask Rudy if he has any maybe a comment or a little bit explanation about our dispute team, please go ahead, Rudy.
Yeah, thank you, Mbak Lia. Maybe I want to add Lia's explanation to Philip's question. Yeah, so basically, for our arbitration practice, we usually represent the client before our Indonesian arbitration body. But like Lia said, if the issues was settled through SIAC, for example, we will usually work together with another foreign law firm. So basically, we will cover all of the Indonesian law aspects. And then we are also currently quite active in assisting the client in enforcing the international arbitration awards in Indonesia. And nowadays, currently, the most active client perhaps coming from China, because they, as you know, perhaps in the recent years, they have a lot of business and investment in Indonesia. So we are currently quite active representing the Chinese client.
Thanks, Rudy. A question from me on enforcement of arbitration awards. What is the attitude of the Indonesian courts to enforcement?
Yeah, so basically, as long as the awards comply with the requirement for the registration, so basically, the Indonesian court will accept the registration. And then the Indonesian court also last year, at the end of the last year, they introduced some Supreme Court regulation with regard to the timeline. For example, to obtain the writ of execution, for example, they already provide like some guidelines to the chairman of the Central Jakarta District Court as the main body who will handle the enforcement process. So basically, there is a specific timeline, but of course, it is not binding, and it is only some encouragement from the Supreme Court of Indonesia. But nowadays, actually, they quite agree with the view from the International Arbitration Award or from the Arbitral Tribunal. So basically, if the issue is related to the commercial dispute and there is no like some issue related to the public policy in Indonesia, even though there is no specific regulation about what's the meaning of the public policy. But if it's commercial in nature and the award is saying that you need to pay a certain amount of the money, so basically they will issue the writ of execution. So it's only a matter of a timeline actually, Wendy, in Indonesia, because there is no specific timeline, although there is like some guideline from the Supreme Court, but it's not followed fully by the chairman of the Central Jakarta District Court. So we need to wait for a little bit longer to obtain the documents from the court, but they adhere the arbitration award in Indonesia.
So, but yes, we had for a time a kind of at each meeting here a kind of presentation from different countries about the enforcement of foreign decisions, foreign awards in their countries, and obviously there is a huge difference in the approach of different countries about the enforcement of foreign awards. Maybe not so much if you look at the law, but in reality. So would you say in Indonesia it takes years, or is it something which is, and well, within 1 year you will really start the enforcement process? It's accepted by the courts, and if it comes to public policies, it's something which is kind of reluctantly applied by the courts, or do they kind of have a rather lenient approach when it comes to public policy? Can you maybe just give us a short picture about what you would advise a foreign company if it comes about enforcement of a decision in Indonesia?
Yeah, so basically for the registration itself, from our latest research with the Central Jakarta District Court, starting from 2014 until now, the numbers quite increased significantly. So basically, the Indonesian court accept the registration, and then for the writ of execution, they also issued the writ of execution. However, the issue would be with regard to the timeline. For example, nowadays, recently we registered some international arbitration award in the Central Jakarta District Court, and then they issued the deed of registration within 1 month. But for the writ execution, sometimes it will take like 6 months until 1 year. It depends on the situation. But about the Indonesian court application on the public policy, so far, I think starting from 2011 up until now, there is only one case whereby the court saying that they won't issue the writ of execution and saying that the award, the SIAC award cannot be enforced in Indonesia because it's against the public policy. Because one of the award granted by the tribunal at SIAC at that time saying that the defendant or the respondent in the arbitration must stop all of the court proceedings in Indonesia. So the Indonesian court view that that kind of action or that kind of award granted by the tribunal is in violation of the sovereignty of Indonesia, because they are not entitled to ask the Indonesian judges to stop all of the proceedings in Indonesia. But it's only one case so far, what we know. So basically, for the investor, it's quite good, but the main problem would be about the timeline for the enforcement.
Okay, that's very helpful. Thanks a lot. So I guess, Wendy, since you're very close to Indonesia, do you have some experience with your clients about enforcement processes in Indonesia? Or?
Well, I think we have had some experience, not quite successful. I mean, I think in terms of what Rudy has mentioned, right, it takes a long time. And I think a lot of formalities, and sometimes there are issues with service as well. So it's not an easy process. I think ultimately sometimes you may be successful, but it takes a long time to get there. And there are cases where we have been unsuccessful as well, because I think of the public policy reasons, or because the tribunal exercised jurisdiction over some parties, which the court then finds actually the tribunal should not have exercised jurisdiction over that.
Just to add what Rudy explained just now. Well, we are talking about the enforcement of arbitration award, but sometimes the client also asks whether the foreign court, foreign decision is enforceable in Indonesia. The answer is no. So, for example, if you have a foreign ruling from Singapore court, for example, and you want to enforce it, then it means you cannot do it. It means that you have to refile the lawsuit here in Indonesia.
Yeah. And so as a result of that, right, sometimes we see in Singapore, people coming to enforce in Singapore against Indonesian parties because of the closeness of Singapore and Indonesia. People who have substantial assets, or companies with substantial operations tend to have something in Singapore. So they know it's going to be hard in Indonesia. So while they may try Indonesia, they will definitely try in Singapore. So we see some of that, not just for Indonesia, but some of the other countries in Southeast Asia as well.
Yeah, correct.
If there are no further questions for Leah and Rudy, perhaps we can move on to the next item on our agenda. I thought this was an area that could be quite interesting to talk about. And it really is just disputes in the sanctions era. A lot of you would know, because of the Russian-Ukraine war, many countries have implemented sanctions against Russia, Russia entities. And that has resulted in quite a fair amount of litigation. For example, Russia has introduced counter sanctions, allowing designated entities or banks to commence litigation in Russia instead of complying with an arbitration or jurisdiction clause. Then that sparked off a whole series of litigation in England and England and Hong Kong, where the counterparties went to obtain anti-suit injunctions against the Russian entities from commencing corresponding litigation in Russia. They got those anti-suit injunctions, but the question is, when it comes to enforcement in Russia, ultimately, I doubt they will get very far. They will probably be found to be in breach of Russian public policy. So I thought, given the number of cases coming out, arising out of sanctions-related issue, that we could probably try to see if there are any interesting issues that you all have come across in your jurisdictions. The first question, perhaps if I just go around the table for us to all talk about, is if you could just briefly let everyone know what are the relevant sanctions regimes in your jurisdictions and something that lawyers will be interested in. So if I give you a short snapshot of Singapore, Singapore has introduced sanctions against Russia. A limited number of Russian banks and entities have been designated by Singapore. The sanctions are only targeted at financial institutions, and in particular of interest to us, financial institutions have to freeze the assets of these designated banks and entities that they are holding on to. It's a very limited sanctions regime in Singapore, but it's there. And it could be interesting one day if someone tries to enforce a judgment against one of those designated entities. If they have monies in Singapore, those monies will be frozen by the financial institutions. Then the question is whether you can execute against those frozen funds. So that's in a nutshell the position in Singapore, in case anyone is interested in future when it comes to enforcement against Russia or Russian entities. That's something that we would have to think about in Singapore. But I'm going to pause here and check if anyone else has anything to share from their jurisdiction on this issue.
I can do from Ukrainian side. Hi, everyone.
Oh, great. Thanks.
Ukraine has indeed introduced a lot of its own sanctions against Russian entities, Russian state-owned companies, and there are many indeed issues with that. So on the Russian state-owned assets and entities, actually Ukraine took steps to directly nationalize some of these assets. In terms of private companies, there are currently also proceedings. So with state assets, the state can do this directly via government acts. With private assets like Russian oligarchs, so if they're sanctioned in Ukraine, as a last step, the new legislation was introduced in May 2022 that the Ministry of Justice could file a lawsuit asking as a last sanction step to actually confiscate the assets. So quite a lot of these proceedings have already happened, and some of the assets were confiscated, and some of the Russian oligarchs actually threatened, and some already filed investment treaty claims against Ukraine. The only one reported that actually proceeded is this Alpha Bank. It's a conglomerate of companies controlled by Friedman. So they were the ones that initiated the exit arbitration, but some of the entities only threatened, like Sberbank and some others. When it turns to enforcement issues, I think in the past there were different approaches, and now the approach has unified. So for example, if a creditor was a sanctioned entity, in the past the courts allowed the enforcement of the foreign arbitral awards, but said that the bailiffs or enforcement officers will control whether in fact it's possible to actually debit the funds or transfer the funds outside of jurisdiction. But later on, the courts changed the approach, and they said that the inclusion of somebody into a sanctioned list, and if there is a specific sanction like blocking of assets, this means that it's not even possible to recognize and enforce. Some of these creditors raised the issue, our claims may be time barred and other considerations, but so far that has not been resolved because potentially the sanctions are introduced for a certain period of time. They can be renewed, but if not renewed, then this creditor could try to come again with enforcement. There is in Ukraine a deadline, actually 3 years from the time of the rendering an award, when a creditor could come and ask for enforcement. In practice, it's treated as a procedural time deadline, and it could be renewed. So potentially, if there is such a situation, then the creditor could ask to renew this deadline. but otherwise the sanctions are strengthened, and the position of courts is also becoming more stringent. So we also observed the case where the company who asked for enforcement of Stockholm Arbitral Award in Ukraine, it was not under sanctions, but the court found that a lot of this, like this receivable, was basically pledged to a Russian bank, and that Russian bank was sanctioned. So the court said the result of this enforcement would actually result in a situation where the money could be transferred to a sanctioned entity, and that was also already enough to stop the enforcement. So we observe these things, how they evolve, and there are new approaches coming like all the time.
Thanks, Olex. I think you've explained the situation when the creditor is a sanctioned entity. What about the reverse? So if the debtor is a sanctioned entity, do you think, and its assets are frozen in Ukraine, have you come across cases like this, and how would the court approach a situation like this?
Well, I think in Ukraine, as I said, most of these assets of these sanctioned entities, the state took them over, either through
Right.
this direct
Okay.
nationalization
Yeah.
or confiscation.
Yeah.
So creditors are really left with not
Yeah.
a lot. So probably
Yeah.
that's why they're trying to search around the globe to find some other
Yeah.
assets. But in Ukraine, those assets were mostly just directly took over by the state.
Yeah, the ISDS case is interesting because obviously you'll be aware of the reverse situation where claims are brought against Russia for expropriation. There are a number of awards that have been coming out already against Russia. And so we're seeing enforcement of those awards in Singapore. Hopefully the reverse doesn't happen and the ISDS cases don't succeed against Ukraine. Otherwise, you might start seeing some enforcement actions against Ukraine around the globe as well.
Yes, we'll see.
Right. Anyone else have anything to share from their jurisdictions? How about our friends from the EU? So I know EU has adopted pretty stringent sanctions against Russia. Have you seen any issues arising out of that or litigation arising out of that?
I guess I'm one of the few EU representatives here. I haven't actually seen any sanctions related disputes related to EU sanctions. I have had a dispute regarding actually American sanctions against a Russian individual. And this was actually a court litigation a few years back. A colleague and I represented a local Swedish company against a very large Swedish metal producer. And this Swedish metal company is owned by a Russian company. And at the time, this Russian company was ultimately owned, at least in part, by a Russian oligarch. And in 2018, I think, this oligarch was placed under American sanctions, in part because of the Russian occupation of Crimea in 2014. And because of these American sanctions, the Swedish metal company was unable to receive payment for long stretches of time. And as you can imagine, this caused a lot of issues, and basically it led to a breakdown of the contractual relationship with our client, and gave rise to this dispute. But in the end, this dispute was settled, so it never had to be decided by the courts. So I don't know how the courts would view it. But well, Sweden is bound by the EU sanctions against Russia, and as you probably know, these sanctions are quite far-reaching. They include export and import restrictions on many goods and services, including many technology, energy, finance sectors. And I did some research before. The sanctions include some 1,900 individuals and entities in Russia. But I'm probably not the right person to give you all the details of this, but that's kind of the scope of it.
Does it include the freezing of the assets belonging to the 1,900 individuals and entities?
I actually don't know really. I believe that much of these assets are frozen in the EU. I know that's one thing. I know the Americans have discussed whether it would be possible to use the frozen assets to finance the contributions to Ukraine. But I also know that most of the assets are frozen in Europe.
Yep.
So that's not really the way forward for the Americans.
And there's been some litigation in England on the use of these frozen assets. So I think the English courts have said it can be used to pay legal expenses and legal costs that are due to the other side. But I think no one has quite determined yet if a creditor can go and seize those frozen assets. I mean, in principle, I would think nothing stopping one from doing that, but no court has decided yet. And I mean, at least from Singapore's perspective, the exceptions allowed for the use of the frozen funds are quite limited. They're limited to like basic expenses, insurance premiums, payments to banks, payments to legal services, but certainly no mention of any payments of judgment sums or award sums. Dimitri, did you raise your hand or were you clapping for Albin or both?
Yes, hi, this is Dimitris from Athens, Greece. Yeah, I wanted to just reconfirm what Albin said regarding the EU sanctions, which apply to Greece, of course, as well. And I also wanted to note that unfortunately there is no Cyprus representative here because Cyprus has been traditionally a significant Russian investment country. I consider that there must have been litigation and need for freezing assets and so on, because traditionally the Russians were using the Cyprus company vehicle, establishing a Cyprus limited liability company, and then proceeding to further corporate tree structures regarding other companies in other EU member states, such as in Greece. So it would be interesting to know the Cyprus issue, but unfortunately, there is no such a case, at least for today. Nevertheless, I mean, my feeling is, I mean, in Greece, no such cases took place thus far. I believe because of the Cyprus matter, because any investments in Greece come based, and any Russian investments in Greece basically come from Cyprus. My feeling, and this is a question, overall question, is that overall, I believe that these sanctions have not had a realistic negative effect to the Russian investments throughout the EU, perhaps with the exception of Ukraine, as I heard Alexander earlier. Thank you.
Maybe just a short comment about Switzerland. It's in the past, Switzerland has always said we are neutral, we do business with everybody. That was, for example, the case in the 80s with South Africa with the apartheid system there. So, but in the respect of Russia, Switzerland has basically adopted all the sanctions issued by the European Union. So the same sanctions apply here. And there are some criminal proceedings now ongoing here about companies and the institutions which are blamed to have tried to circumvent the sanctions. And yes, and of course sometimes it's probably also quite difficult to really find out who is behind the companies, since yeah, they use often companies which are not so obvious, and there is the famous example of the it's kind of he's a musician, and he had a huge amount of money in Switzerland, the guy, and basically it is assumed that this is actually money of Vladimir Putin, and that he is hiding the money for him. But yes, he claims that he has been investing and things like that. So it's often it's not so easy to prove who is the actual owner of the money. Nowadays, of course, the money, I think that the most attractive places for the Russians, they are currently the Emirates. There's also a lot of investments going on there from Russia, and another place where they are quite safe is Turkey. So right now, Switzerland is not an attractive place for Russia any longer.
Yeah, Singapore is the Switzerland of Asia, but we adopted very limited sanctions as well, much lighter than the ones in EU. But I think Singapore felt we had to take a stance, given we are a small nation and we align ourselves in some respects with Ukraine's position. That created some stirrings in the community about, are we doing the right thing? Because Singapore for a long time spent a lot of time trying to lure Russian disputes to Singapore. So SIAC spent a lot of time in Russia, and the initial backlash to those sanctions was something that was quite debated. But I think it's kind of like died down since then, and we're starting to see Russian investments coming back into Singapore. I was going to ask Tony if I'm curious, what's the position in Brazil? Because I don't really know much about the Brazil position.
Yes, good morning, everyone. Good afternoon, good evening. Brazil has maintained a very neutral position. I mean, as it is common in our constitution, we're not supposed to interfere. Of course, our current president has stepped up the rhetoric in a way that most Brazilians didn't like it. But so far, there are no sanctions. There was some discussions at the beginning of this unfortunate war to impose sanctions on Russia, but the then president decided not to do that for basically pragmatic reasons. There's a lot of need for not only oil but fertilizers from Russia. We are an economic, agricultural powerhouse. So the government then and the government now decided to take this more neutral approach. So we haven't seen anything. Of course, some of our clients ask us about these, but so far there are no sanctions specifically in connection with this war. So what we do as Brazilians is we reach out to our friends in Ukraine. That's what we can do.
I think, Wendy, because you mentioned arbitration, I think that would also be something to be addressed by Albin, because while we were not too successful in Switzerland to attract arbitrations from Russia, that Stockholm used, or probably still is, with existing arbitration clauses, a real hub for arbitrations related to Russia. How do you deal with those cases?
I actually couldn't really say, but could you specify the question?
Yeah, one question is, I assume that probably nowadays the Russians would not conclude arbitration clauses with Stockholm as venue any longer, but of course there are also pending arbitrations, and assuming, for example, an arbitration involves a sanctioned party, what is the impact on the arbitration?
Yeah,
I did not really check that in the past, so I thought you would be better informed, because it's probably more a topic Sweden, I assume.
Yeah, I guess it probably is. I haven't heard much about it actually, and I guess one of the reasons for that is the confidentiality clauses of these arbitrations. So I really couldn't say. Sorry.
Yeah, but I think part of the reason for the English cases. Sorry, Dimitri, please go ahead first.
Well, I wanted to know that this would be apparently a public policy issue, namely that any mediation or arbitration as ADR could not proceed, could not take place in those circumstances, because the special legislation of sanctions regard the public policy issue, as I see it, of any jurisdiction. And therefore, since public policy and morals are the ultimate boundaries of any ADR, arbitration, mediation, I consider that any effort to proceed with an ADR such arbitration could be invalid. This
So
is my legal view.
the English position, there have been some cases coming out of England where the English court said that the public policy in favor of access to justice requires the court to allow sanctioned entities to continue claims in the English court, and conversely to allow them to defend themselves in any claims that are brought against them. The Russian, as I understand it, Russia has come up with counter sanctions. They legislated a law which allows sanctioned entities to commence actions in Russia in breach of any arbitration clauses or jurisdiction clauses on the basis that, well, you're not going to get any real justice in those jurisdictions, I think precisely for the reasons that you've highlighted, Dimitri. So we've seen, I think, that the cases I've read in England and Hong Kong, where the Russian entities have commenced action in Russia on the basis of this new Russian law, and their counterparts have then gone off to English courts and Hong Kong courts to obtain anti-suit injunctions against them on the basis that, well, you still have a right to access to justice. Just because you're sanctioned does not mean you cannot bring claims or you cannot defend claims in England or in France or in Hong Kong.
Yeah, actually, Wendy, that reminds me, like at the beginning when the war started, we had a lot of clients who wanted to exit the business in Russia, and that they were also struggling with the anti-sanctions or anti-measures issued by Russia. So, for example, if a company would terminate a long-term agreement referring to the war, that would be considered invalid and would then have opened the claim in Russia. So we had always to find a reason, excuse to terminate the agreement without referring to the war. So that there are sometimes interesting questions which arise.
Maria, did you want to say something?
Yes. But in Chile, through the years, has reiterated its support for Ukraine and reaffirms the condemnation of Russia, but we also have had limited sanctions, very limited sanctions. I remember in 2022 that Chile has publicly joined the international sanctions against Russia and withdraw invitations to Russian companies that will participate in the International Air and Space Fair. It's called FIDAE, that was held in Chile. I remember that the Ministry of Defense of our country points out publicly that this was due to the aggressions against Ukraine that Russia is carrying out. So the condemnation was always public, but the sanctions were very limited also.
Thank you. I think we have about 10 minutes left. Maybe we can move away from the topic of sanctions. And I just open up the floor to anyone who wants to raise anything interesting to the rest of the members here. You know, anything interesting you're doing now, anything interesting coming across your table. Yes, Tony, please.
Hi, thank you very much. No, it's very quickly an update here in the Brazilian judicial courts. Companies, they have until the end of May now to register in a centralized online system that is maintained by our court system. It's called Electronic Judicial Address. This essentially will be our centralized system for electronic service of process. We are moving away from letters, from paper, from anything like that. I mean, our system is entirely electronic now, but for the service of process. So this system will consolidate all notifications and communications from Brazilian courts in a single location. Again, there'll be no more paper. The idea is that, so every single notices or service of process or any procedural notifications will be served electronically. So if you have clients incorporated in Brazil, they should be aware of this new system. Of course, we can help and assist in registering, and companies have until the end of May to do so. Otherwise, they may face some sanctions. So this is kind of a judicial update here that we are letting people know.
That's very interesting, Tony. So companies have to register, and papers can be served on companies through this electronic system. So if I am commencing an action against a Brazil company, you can serve those Brazil hot papers on the Brazil company through this electronic system. So there's no need to physically serve documents anymore.
That's exactly right. The way
wow,
it is,
that's very advanced.
Yeah, I think it's. I mean, of course, we are always concerned because we rely so much on the paper, on having the paper, the service, and then the papers return to the court, and then we have our deadline to respond. Right now, it's going to be. I mean, it's going to be online, everything online. They're going to be by email or in this electronic. It's basically a website that you go there as a company lawyer or even the outside counsel. They can go there and say, let's see how many lawsuits we have, and there will be a deadline for you to basically press enter and see what you have against you, and then
that's fantastic. Yeah, that would really help with issues that come about when people avoid or evade service, right? So you can go to companies and the receptionist refuses to accept service, and in Singapore, how we get around it is the law allows us to just dump the documents in the registered office, and that's sufficient. Some jurisdictions I know, maybe Indonesia takes a different approach. I recall Vietnam takes a different approach. You need to actually have a person authorized to accept service on behalf of the company to sign on the documents. So that's always very hard when you're going against a defendant who's not going to accept service.
That's true. Yeah, hopefully this will help in these situations, and you're absolutely true. I mean, if you want to avoid a service, that's what people do. I don't have powers to do that. I'm not going to do that. With this new rule, it's supposed to streamline things. So we have a very electronic judicial system. This is yet another step towards this digitization. So it's supposed to be interesting. But companies, of course, they're all
Sorry, Tony, we lost you for a bit. The last 30 seconds or so.
We can see that your face is moving, but we cannot hear you anymore. It suddenly stopped the voice. No, there's no voice anymore.
I think Tony's had some issues with connection because I've seen them come in and out.
The point is obviously the connection is working because you can see how the face is moving, but there's no sound. I think it's the problem. It's only the sound, not the connection.
Ironically, when we are talking about electronic service.
Exactly.
Right.
Sorry, can you hear me now? No.
Yeah, now you're back.
Yes.
Sorry, my headphone died on me. Sorry about that.
Anyone else have anything interesting?
Tony, if you have international service, probably that will be still by paper, or you just ignore that.
No. International service of process will be through letters rogatory. We are signatories of the both conventions on the issue, but this will be the same. But these are not, of course, the majority of cases in Brazil. What the Brazilian judicial system is trying to curtail is all the papers for the small claims here. But the big ones, are still going to be through paper.
I just wanted to follow up actually the same update from Ukraine. So we do indeed have also the same electronic system. It was introduced last year, and basically from October last year, it was introduced in commercial cases, and from January this year in civil cases. So every Ukrainian company has to have this electronic cabinet, and if it's a respondent in a lawsuit, it should receive papers from the court. And if a company doesn't have this cabinet, then basically the court will send them a notification saying that you are respondent in a pending lawsuit. To actually see what it's about, just register. So the court will not send anything to this company. So if a company still does not continue and still does not register, the court will just send this notification, just go and register. And otherwise they may get a default judgment. So basically that's the system of encouragement, how to get the companies on board. But there are no like sanctions saying that you have to pay some fine or something like that. So it's basically, if you're active respondent in proceedings, then you will feel this in any way. And the lawyers also have to register now. So all the attorneys have their own cabinets. So for example, if it's a foreign company, and for example, you are a foreign company wanting to file a claim, so your attorney would need to do it through his or her cabinet. So it's quite efficient. And if somebody still files something on paper, it's possible for the court to scan everything and still put it on the system. But it's still in this first very initial phase.
Well, if no one else has anything interesting to share, Philip, Ryan, should we bring a close to our session today? And Hannah, could you just remind us when the next dispute resolution meeting would be?
Let me take a quick look at the calendar, because I do think we have it on the website already.
The next one is certainly the physical event at the occasion of the meeting in Bali.
Right.
Yeah.
We'll be able to attend there, and then it will be.
It looks like the next one we have on the schedule is September. Does that sound right? September.
Yes, 10th of September.
Okay, and I will drop in the chat the link for that so that you all can go ahead and register and add that to your calendar.
Yeah, and if you come across anything that you think it might be interesting for us to discuss at the meeting, please drop Ryan, Philip, and I a line. Any interesting topics or issues that you think would be useful to hear from members from across various jurisdictions, please let us know, right? Whether it's enforcement, anything new coming out of energy disputes, for example, anything of interest to you, please let us know so that we can include that in our next session.
Yes, and I would like to know if you guys happen to be traveling for anything, whether it's a client or social, or if you're going to some sort of industry event, let us know. We're happy to connect you with the local members in the jurisdiction. I know Wendy and Philip met up earlier this year when Philip was in Singapore visiting his son at school. It's always nice to meet in person when that's possible. So just let me know and I'm happy to help make those connections.
Yeah.
Okay, great. Thank you all for joining. Leah and Rudy, happy Hari Raya in advance. Thank you for joining us, even though you're celebrating some big event tomorrow.
Yes, thank you, everyone.
What? Sorry, you have to explain that. What is that?
it's the end of the Leah will explain it a lot better, but I think it's the end of the fasting period
Oh, okay.
tomorrow. So everyone celebrates it.
Okay.
Right.
Okay.
I'm looking at Leah to give a better explanation than that.
Yes, it's a Idul Fitri celebration here in Indonesia.
Okay. Okay. So then, so you will have a day off tomorrow then?
Well, actually, this week we have a
Ah, the
public
whole week.
holidays.
Okay. So you have to
Yeah, whole
work
week.
so fast. Sorry for that.
She's joined us on
Yeah.
holiday on her time off. Thank you, Leah and Rudy. We really appreciate it.
Uh,